contact cases. This is oh gosh, right. And secondly, guidance has been issued in response to this research on a number of occasions. First of all in 2001, then we get 2008, 2009, 2014, and most recently 2018, which has established a framework that's supposed to be followed in court to prevent this minimisation, to improve the safety of victims in contact cases, including the establishment of fact-finding hearings where domestic abuse has been alleged. That all sounds great. However, unfortunately, we see also a pattern which a practice direction is issued, and then research demonstrates that implementation of that guidance is patchy and inconsistent and leads to unsafe decisions on contact. And there's been various analyses of why this happens and what goes on. One of the most important ones is by Marianne Hester, which is called the 3-planet model. And she analyses how the family courts are on one planet, the child protection courts are on another planet, and we also have the criminal courts on a completely other different planet as well. And they all 3 of them have different approaches in relation to the safety of children. So you've got the criminal planet saying to mum, must not have contact with father perpetrator of domestic abuse. You've got the child protection planet saying the same thing to mum as well, otherwise we will remove the children. But then you've got the family courts saying, actually, you're supposed to be allowing contact with perpetrator / father of the child. So you can see that this causes issues. And that's also been termed, the other issue that's been particularly prevalent and has been evidenced by the recent harm panel report that was commissioned by the Minister of Justice is this contact at all costs approach, which is what we have in general in England and Wales. And this has been influenced by a largely successful fathers' rights movement, which has used human rights narratives and parental alienation in particular very successfully. However, as I've noted in my research on this, there's no corresponding mothers' rights movement or the use of human rights narratives by any kind of movement on behalf of mothers. And finally, just to make things worse, we have illegal aid cuts introduced by LASPO in 2012, which actually makes it very, very difficult for both parties actually to obtain legal aid and get legal representation in such cases before family courts. So that really kind of gives you a picture of the context in which this research was operating in terms of legal response. And finally, the private nature of family law proceedings also makes it very difficult for scrutiny. There's a lack of public scrutiny. There are very good reasons why we have privacy in relation to cases involving children, but that does add to the general kind of problem of a lack of scrutiny in this area. So the next issue, or the next point that I wanted to stress here is the applicability of the HRA and the ECHR. And that's something that unfortunately we don't see addressed very much in the case law in this area. So we know Section 6 and Section 3 set out the court's duties in this regard. So the court has a duty upon itself to step in and to implement the Human Rights Act where it is relevant. We also know from Strasbourg that they've established that domestic abuse falls within the scope of a number of articles, and particularly 2 and 3, which are absolute articles. And in relation to those 2 articles, the responsibility of the state is to undertake effective investigations and risk assessments in order to protect victims from domestic abuse and to protect children's dignity. Under Articles 2 and 3 versus Article 8, which is the right to family life, which is a qualified article, we know that the perpetrator's right to family life can't trump the state's obligation to protect a survivor and her child's Article 2 or 3 rights in a contact case. So if a case was to come before the courts about contact and you've got a situation where you think Article 2 or 3 has potential to be engaged or is within the scope of that, Article 8 can't trump those arguments. And that's a really, really important point, I think, to remember going forward. And in terms of Article 14, we know that a state's failure, even if unintentional, to protect women against domestic abuse will breach their rights to equal protection of the law. And it's been commented in the case of Opus in Turkey that a general and discriminatory judicial passivity on the issue is also capable of creating a climate that's conducive to domestic abuse. So those are all really, really important points to note in relation to the applicability of human rights in this area. And finally, the main point, we have seen no references to Articles 2, 3 and 14 in any of the contact cases concerning domestic abuse. So despite all of that, despite all of those particularly important points in relation to domestic abuse, which we're seeing at the, I guess, regional European level, we're not seeing it at the domestic level at all so far to date. So this context was really what led to the project with Women's Aid that I commenced a couple of years ago. We managed to get some funding to undertake an empirical research project, because I was really interested in hearing from survivors themselves about the impact of human rights. And that's really essentially what I do in my work. And so the methodology was as follows. We used quantitative and qualitative methods. There were 72 women in total. There was an online survey. There was a short follow-up survey which focused on human rights. And there were also 2 focus group discussions with survivors. And then we also had individual telephone interviews with survivors. And here were some of the main points. 90% of survey respondents, the perpetrator of the domestic abuse was a male former intimate partner. 60% of them had experienced physical abuse, 57% sexual abuse, 95% emotional abuse, 83% financial, 89% coercive and controlling behaviour. And not quite a few of them obviously experienced a number of those. It wasn't just one or two. They experienced quite a range. And then I'm just going to go through the findings. I'm focusing particularly, there were a number of findings in relation to fact-finding hearings, but what's particularly important for today is looking at the findings in relation to human rights. So in terms of the use of human rights, the initial survey demonstrated that the right to family life, Article 8, was raised in 49%, the right to be free from inhuman and degrading treatment in 9%, and the right to life 7%, so very low. So predominantly it's Article 8. 42% of survey response, however, said that human rights had not been raised in their case, despite the fact that the overwhelming majority had experienced domestic abuse and had actually reported this to the police. And bearing in mind, again, the stat at the beginning of this presentation in relation to over 50% of these cases involved domestic abuse as well. So 42% said human rights had not been raised. And in terms of Section 6, under the Human Rights Act, 65% of respondents said that human rights were not raised by the court, compared to only 3% of cases where the court did raise human rights. However, when we looked at the free text answers in relation to that 3% of cases, they indicated that judges in these cases only raised the human rights of the children and the father to have contact, but not the human rights of the mothers at all. So various conclusions could be drawn about that in relation to the courts not taking their responsibility seriously into Section 6. So the court can obviously intervene themselves if they find it relevant. So what we saw was that Article 8 was given higher priority over potential Article 2 and 3 claims in general. And here's some quotes from free text quotes from the empirical research. So you can see here, this is one of the focus group participants who said, that's what he went for, Article 8. And my response to that, which my barrister didn't pick up on, was what about my right not to be abused and the coercive control thing with children? But no, they didn't go for that. It was just accepted. Let's move this out of the way, I can actually see. It was just accepted by the judges that he's got a right. Let's give it to him. And I thought, no, he's abusing his children. This interview participant talked about the fact that the judge kept reiterating to the ex that he had rights. And the ex kept saying, I'm not doing this anymore, I'm leaving, I can't be doing this with this. And the judge kept saying to him, you do have rights, you've got father's rights. So you can see here, a judge is actively intervening on behalf of a father in relation to accessing his Article 8 rights in court. We also saw judicial evidence of judicial failures, generally in terms of keeping women safe. There was a complete failure really to consider Article 3. Direct contact was awarded in the majority of cases, despite 71% of cases involving domestic abuse, and there was no order for contact in only 11% of cases. There were also judicial failures in relation to discriminatory practices. Cross-examination was allowed by the defendant to a former victim of domestic abuse, which is now happily not going to happen under the new Act, but previously was allowed. Unprofessional behaviour in general and victim blaming attitudes. And here's some examples by a focus group participant. And she says, I thought I had the right to a fair trial, the right to be heard, to speak, but I was repeatedly told by the judge to shut up, by various judges to shut up, just shut up. And I was referred to not by my name, but my status as a wife, even though I was divorced. And also referred to as you, not Mrs. or Ms. or anything but you, whereas he was repeatedly called by his name, given a status and title while mine was taken away. Here's another participant. When a mother goes into court, you have to come across very calm. You can't show emotion. You can't get upset. If you get upset, well, then you're unstable and you're not healthy for the child. You're not acting in the child's best interests. They say, if that's what you're like with us, then that's what you're like with the child. No wonder she's like this. But if the father goes in and shows emotion, the judge will turn around and say, well, he's hurting. Of course he's like that. He's hurting. He's not seeing his child. It's so different how the two are treated. And here you've got her articulating really double standards that are applied really to men and women in relation to claims made in the family court. We also saw that women were unable generally to harness their human rights. They were more likely to focus on their children's rights, while the men were more likely to advocate for their own rights. And there was evidence that their rights were rather lost in the process as a result. And some of these quotes for me particularly were particularly difficult as a human rights lawyer to hear. I would say that when you say the word human rights, in theory, that means civil liberties and having individual liberties and rights. So the women here are really articulate about their understanding of human rights, which is really good to see. But depressingly, that didn't really in any way translate into practice. So she says here, but in practice, in my experience, not only did I lose my rights by being in an abusive relationship, that was perpetuated by the family courts afterwards. This is another one. I don't believe I had any rights in court. I don't believe I had any equality or any equal rights in court. It never came across like that. We were there to make contact happen between father and child, and that was it. My human rights, I just think they're broken, and they're not even in the same picture. I don't think they're in the same building. And this one, my rights were never brought up. My right to walk away and be safe. I was with him for several years, and it was just absolute hell. When I was pregnant with a little one who tried to kick him out of me, but they knew all this. It was in the police reports, but they were still pushing for him to have contact. So those are rather depressing findings, and in itself is a really important, I think, contribution to the literature. But I also wanted to understand this from a kind of macro level, really. And to do so, I theorized the findings using the concept of performativity. And performativity is a really interesting way, I think, of looking at this issue. It illuminates really the discursive forces that I think construct and normalize legal and political practice. So let's just as a kind of a précis of what performativity actually is, for those of you who haven't come across it before, I'm sure you have, but anyway, just in case. So Judith Butler is obviously the person that's associated with performativity the most, although it's clearly not just her ideas, but she talks about it very much in terms of gender and gender performance. But it's very interesting in general to look at how it's been applied in different contexts. So a performative for Butler is defined as that discursive practice that enacts or produces that which it names. And for her, speech acts are either illocutionary, saying what they say and doing the moment of that saying, and perlocutionary, that have produced certain effects to their consequence. By saying something, a certain effect follows. So the example that we'd give in family law, an illocutionary act would be the pronouncement of marriage. The fact that you pronounce the marriage has happened, it's happened, it has that effect. Perlocutionary would be an order for contact. So the order for contact's made, however, the effects of that, the contact follows later. And Janet Zignon has used the concept of performativity to analyse how human rights come into being as a result of this kind of analysis. And she argues that in contrast to the declaration of the inherent existence for human rights in the UNDHR, it's the recognition of that inherence, the perlocutionary effect, that provides the grounds for human rights. And she says, when human rights are referenced, cited and repeated in and by other documents and actors, this results in a performative iteration that works to lend legitimacy and authority to an international system. And this in turn brings into being and maintains the truth of the global morality of human rights. So it's the recognition of rights that bring in the reality of human rights, as far as she's concerned. It requires two things, though, to happen. First of all, we need the state as the constantive guarantor, evidenced in every subsequent recital of the treaty or law, which addresses either the relationship between states and individuals and provides human rights with actual and practical effect in the world. And it also requires a dialogical relationship between illocutionary and perlocutionary to maintain this truth. And that's achieved by the continuous reaffirmation of the existence of human rights in each utterance, and the manifestation of this truth by institution, groups and individuals who provide services or mobilise political action in the name of human rights, which achieves their truth. And I think for me, this is the most important aspect of this analysis, these felicity conditions. And those are crucial, really, to ensuring, I think, that human rights really have any real basis. And those felicity conditions are international funding, media support, and international and transnational government rhetoric and policy aimed at disseminating the transnational moral truth of human rights. So we need all this to constantly keep the process going of ensuring that human rights actually become something real. Oh, here we go again. I'm sorry, I moved this again. In this way, the foundation of the global human rights system she argues, was a result of a performative constantive manoeuvre which brought into being the foundational truth of human rights. Now, this analysis of performativity in human rights has also been applied by Karen Zeavy. But before I go into that, I just want to highlight something that Judith Butler's talked about, which she calls perverse reiteration. So when she's talking about reiterating in this process of performativity, she's saying repetition is not exact replication. Signs can be misheard, misinterpreted, or deployed. And that's a really important aspect of it, which I'll come on to later. But Zeavy has also analysed the women's human rights movement in general using performativity in a particularly interesting way. First of all, she argues that in using the discourse of human rights, the norms of liberalism are not simply reiterated but challenged, because the very norms that are cited are premised on the exclusion of those who cite the norm. So when women use the language of rights, which traditionally excluded them from the understanding of the human, they're not simply suggesting their inclusion into the understanding of human, but instead challenging us to rethink the meaning of the human and exposing the conventional limitations of the human while challenging its universality. And finally, rights claiming by women and other traditionally excluded groups thus entails this double movement. It's not just a citation of liberal norms, but their transformation. And we can see how that happened in relation to the success of the women's movement at the international level in terms of human rights law. We can see that with the campaign, the slogans, the performative reiteration that took place in relation to the slogan of women's rights are human rights, and how that led to the development of a global violence against women movement and the framing of violence against women as a human rights concern, which has led to various concrete actions being taken, and I've listed them there. We've got general recommendation, we have a due diligence standard, we have a UN rapporteur. It's basically the re-gendering of human rights that's taken place. Rights claiming on behalf of women victims of violence has thus resulted in a high level of performativity at the international and regional level. And that's been achieved by a number of things. First of all, the transformation of human rights norms in a process of double movement. So we see that the meanings of human and due diligence were successfully challenged through a process of perverse reiteration, as Butler has argued, in order to rethink their meaning and to expose their limitations in reflecting the experiences of women victims of violence. So therefore, we bring into the existence not just human rights, but women's human rights. And in terms of the perlocutionary recognition of the constantive guarantor, so it's international and regional human rights institutions and state authorities who have ensured that these rights actually have actual and practical effect in the world. And that's been done via the establishment of new norms and principles applied by the courts towards individual states. And that's why we have those very important decisions by the CEDAW Committee and by the European Court of Human Rights. And it's all happening, I hope I demonstrated through this process of performative reiteration, but within this very specific case of human rights and women's human rights in general. So that's great. We achieved a huge amount, I think, in terms of the international and regional level. But what happened to the domestic, going back down to the project again? Well, I think it's evidenced by work done before me, but certainly by the small project that I completed, that there's a high level of non-performativity of human rights of the women that participate in the project. And here's an example from a focus group participant. She says, in terms of what my perception of what my human rights are before I went through the family courts, and what my perception of what my human rights are having been through the family courts, is that there's a huge difference in what I thought my rights were and what I experienced my rights to be. I think I walked in thinking I had them, and I walked out thinking, actually, no, I don't. I walked into court thinking I had rights, but I came out thinking, actually, I don't. So it's a pretty poor performance. Others simply felt dehumanized, actually. So not even just a bad experience, just dehumanized by the whole court process, not a person to whom rights apply. Here's a quote. Through the court process, I still didn't even feel, because I was still very much a victim, that I was even a person at that point. I didn't exist. I was very much in the place of being a victim. So as I was going through the court process, the right to torture didn't even enter my mind, because that was my role, and is my role in this relationship, is to be the one who's tortured. And for me, because of where I was as a victim, I wasn't even in a place to even imagine I had any worth, to have rights. I know all about it. I know the ethics, but as a person, the place I've been put by this man meant that I didn't have any rights, because that's the whole point of violent and abusive relationship, is you are there because your rights have been taken away. And the experience of the women in the sample generally is that the impact of human rights law was minimal or non-existent. And I think that's due to a number of factors. First of all, the court's failure to act in a manner compatible with their human rights, and members of the legal profession either unwilling or unable to advise on their applicability. And we have lots of examples in that if you want to read about it, but from the empirical research where women were actively told not to bring up domestic abuse because it would either irritate the judge or it just wasn't relevant, or, you know, which was obviously incorrect. Court proceedings being undertaken in a discriminatory manner and evidence of a passive climate of discrimination and bias towards the right to family life of the perpetrator. And here's an example. He could do anything. He was dragged out of the courtroom 3 times by security, and we had one day when he was kicking off so bad, we got another 6 security from another part of court to come and stand on that floor. So that's how it was constantly, but his behaviour was tolerated. In fact, the judge praised him one day and said, "Can I just say thank you for being calm?" I'm not sure that would have happened had it been the other way around, and I think that's the point that this particular person was making. So the impact of the women's human rights movement was also minimal. We can see from the sample that we looked at that there was no evidence of any perverse reiteration of women's rights as human rights going on. The family court simply reproduced the authorised and established discourse and norms of human rights in their, I would argue, unreconstructed liberal form. The public-private dichotomy was alive and well. The regulation of the private sphere of family and the relationships between individuals was left entirely within the family court's discretion, undisturbed, from what I could see from this sample, by human rights law. There was little or no evidence of the rethinking of human rights law in practice to include women victims of domestic abuse and to reflect the realities of these women's lives. And in direct contrast to the experiences of the men in the sample, who had a high level of performativity, for most of those men, each illocutionary utterance of their right to family life actually was followed by an obvious perlocutionary effect. They were awarded contact. The court here was acting very effectively as a constantive guarantor. There was a constant reaffirmation of the right through the process. And this was enabled, I've argued in the piece that I wrote up later on, this has been enabled by a wider public discourse, which has successfully harnessed human rights discourse via the fathers' rights movement. And therefore you can see they've got the ideal felicity conditions to use human rights discourse very effectively. So what we've got is we've got a situation where we've got a quote like this coming out. This is shocking, but this is what I've thought at various stages that I've gone through the court process. I wish I'd never gone to hospital. I wish I just kept shut up about it. I wish I just kept on biting the pillow, because actually going to court was the worst thing ever. I couldn't protect my children anymore because of the law. And I think that's a really, really serious indictment of the state of the law, where you've got a woman who has gone to the law to try to, she sees it, to achieve some justice, to protect herself and her children from further abuse. And her conclusion at the end of the proceedings is that it would have been better for her to have stayed in the relationship, which is often a reaction that we do see from domestic abuse victims, because they want to know how to manage that situation better. But for this particular woman, that's her conclusion. I think that's a really depressing state of affairs. And as lawyers, I think we really need to do something about it. So what can we do about it? The way forward, as I suggested, is we obviously need better training for all professionals in the family courts, particularly in relation to human rights law and practice. We need specialist training on human rights law and the dynamics of domestic abuse for the judiciary. And women's organisations need to reclaim human rights narratives and remobilise from the perspective of women's rights as human rights. And that's it. I hope that was
Thanks very much, Shazia. It was absolutely fascinating. I'm wondering if people might like to have access to your slides, and I'm just wondering if we might be able to do that.
Yeah.
Now. So we'll try and work out how to do that.
Yeah, sure.
In the meantime, thank you. It was really, really very interesting indeed. Olive, now we're going to turn to you to tell us a little bit about your understanding of this from the perspective of somebody who represents women in these circumstances.
Yeah, thank you. And thank you for inviting me to speak. I mean, I think one of the first things that I wanted to say is that this event for us is incredibly well timed, because it really coincides with a lot of thinking and conversations that we've been having at Rights of Women about exactly these issues, or this very specific issue around human rights, women's rights in family courts and contact proceedings. So it really is perfect timing. And I think Shazia is completely right. Everything that she said, I agree with. I don't take any issue with anything that she said at all, but I thought, given that we have been having some of these thoughts at Rights of Women and some of these conversations, that maybe what might help is to explain some of the conversations that we have been having around and where practically we think there may be space for change. So I think for us, really exploring how we can actually change things is really at the root of what we do. And I think in relation to this issue very specifically, my view at the moment is that for us to achieve the most kind of seismic shift is going to have to come through case law. So I think there are some really significant issues about and barriers around why this discourse or women's rights have not been pursued properly through case law to date. But I think it has to come in that way, and therefore it has to come from legal professionals. It's not going to come from unrepresented parties. The women that we support are not going to start raising their Article 2 and 3 rights faced with magistrates who will look at them like they've got 3 heads. That's just never going to happen. It's completely unrealistic to expect it to happen in that way. So we need to be working with lawyers who are actually doing this work. And I think there are real barriers there, not only in relation to culture, but the reality is that most of the lawyers that do this type of work are junior. And actually, I think most family lawyers are not particularly radical. That's just, I think, part of the nature of family law. And the young lawyers who start doing this work, they really become quite quickly indoctrinated into a system that has particular cultural practices and attitudes. And shifting those cultural practices are the hardest thing to do. And I guess our conversation about human rights actually came out of where we started was, how do we actually shift these attitudes? And human rights was how we thought maybe that we would be able to start to do that. But young lawyers who are doing this work, they get pretty quickly indoctrinated into the ways that the family court does things. And those cultural practices include pretty misogynistic views about differences in relation to mothering and fathering, which I think is at the root of a lot of the problem. But in particular, things like the Harm Panel report identified, these 2 particular cultural issues: the pro-contact culture or contact at all cost culture, and the minimization of domestic abuse. And these problems are very much cultural. Family lawyers do not think that they are ignoring women's rights. That is not what they're doing. They ask a family lawyer and they'll be able to tell you about Article 8 and the UN Convention on the Rights of the Child. But actually, which interestingly, I think is most often called upon to support really the father's Article 8 rights rather than something that's independent to the child's. It's about the child's right to contact, which is really just an argument in support of the father's rights. So family lawyers think they're doing the right thing, and they don't have they're young and they don't have the capacity and the time to be reading academic articles, or even most of them probably don't even know what CEDAW is. So they look to the domestic case law to develop their ways of thinking about these things and their arguments. So I think we have to start working out how we can develop case law that raises these issues. And that means working with the lawyers that are making the arguments in the first place, because the case law is developed by the legal arguments that are presented to the court. So what we need is some lawyers who are willing to kind of look a little bit sideways, away from the case law initially, and go, actually, okay, this is what the case law has been saying so far, but maybe we've been missing a trick here. So that's where what Shazia has said about the women's movement, I think really gives me a lot of pause for thought about the ways in which, or the kind of environment that we create and the ways in which we talk about these issues. And in relation to the women's sector, I don't have any particular answers, but I have a few thoughts about what has happened in relation to women's rights and our use of women's rights. I think very specifically in this space, because there are different things that go on in different spaces, but in this particular space, I think there is something that's quite specific has happened. The first thing is the funding landscape. It's a lot easier to get funding if you are talking about children's welfare than if you're talking about women's rights. That's the reality. It's the reality that we find. We don't support children directly. We very much provide services to adult women. But in our funding applications, we talk about the number of children we impact because the women we support have children. So there's problems with the funding landscape. But there's also been a kind of corporatization of certain parts of the sector anyway, that leads to the need to kind of maintain a certain amount of respectability. And when you have to appear respectable because you want to get your foot in the door, you want to get in front of MPs, ministers, civil servants, and have them listen to your arguments and take them seriously, I think there is a little bit of making your arguments in a way that you know are going to be palatable. I think we're all responsible for doing that. But the final thing, which you perhaps, again, we've taken our eye off the ball a little bit, is that our service users, so the women that come to Rights of Women, when they come to us for advice, they don't call us up and say, my human rights have been breached. When they're asking us for advice about contact, their framing is almost always, look, I'll do whatever, just as long as the children are safe. So that kind of framing also comes directly from most of our service users. And again, as a sector, we kind of, we talk about the fact that we amplify the voices of our service users, and service user engagement is an incredibly important part of it. And perhaps there hasn't been, again, from us enough sideways looking and thinking about, okay, well, this is what our service users are saying, but how do we actually then apply the law or think about that in a slightly, we're still promoting what they're saying, but thinking about it in a slightly different way as well. So I think those are some of my kind of practical thoughts for us as a sector. Yeah.
Thanks, Olive. That was really interesting and helpful. And I wondered, Shazia, while we're waiting for questions to come in, if you might talk a little bit about, which you outlined at the beginning of your talk, the intersection between Article 8 and Articles 2 and 3, and how that has worked out both in the jurisprudence of the European Court, but also whether there are any member states of the Council of Europe where you think either legislation or courts have got that balance between the right to life and the right to be free from cruel and unusual punishment and personal security of the person against the right to family life in Article 8 appropriately balanced, or whether you actually see this as an endemic problem across all the member states of the Council of Europe.
So I'll answer the last one first. I think it's an endemic problem across all the member states, which is why I'm doing the research I'm doing. But I think also we haven't seen any cases specifically on contact. So we've seen cases where Article 8 and Article 2 and 3, as you probably know, Kate, have been, I'll just drop my pen, sorry, have been, which is why we know the principle, which is that as much as there is a hierarchy of rights at Strasbourg, there's definitely, Article 8 cannot trump, a qualified article shouldn't trump an absolute article because of the duties that are imposed in relation to absolute articles. So we know that, but there haven't been any cases specifically in relation to contact and domestic abuse that we've seen. We've seen cases where contact and domestic abuse have featured, but we haven't seen the arguments of Articles 2 and 3 versus 8 in the same way. But I suspect, so as we always know with these, when the right case comes up, it will be good to see what happens. But yes, I mean, I think to a certain extent, there's been a real failure in general, I think, within family law to deal with, and I'm talking about the domestic courts here, to adequately deal with human rights in general, which is quite interesting because as soon as, in terms of the Human Rights Act, when it was enacted, I remember a lot of, and in fact, still a lot of the key cases under the Human Rights Act are actually under Article 8, as we know, right? So, and it's really strange. It's also so that I find that really bizarre because I'm kind of half a human rights lawyer and half a family lawyer, and human rights lawyers are always quoting cases from family law, but I don't find that family lawyers are doing the same. So it's almost as if it kind of bypassed, to a certain extent, for quite some time, most of the the academy in family law. I think that's changed over the last 5-6 years, which is brilliant. But it's certainly bypassed quite a lot of judges and quite a lot of lawyers. And it might be for the practical reasons also that Olive's talking about in relation to younger lawyers that are coming in who clearly have been told and taught about human rights, in their courses, whatever, and degrees that they've taken. But as you say, the culture is so endemic, Olive, that it's really, really difficult for them to even try to raise those concerns and raise those issues. So I think there's a problem, first of all, with understanding and applying Article 8, which is in itself, let alone looking at Article 2 and 3, and then let alone balancing those 3 articles together. And there are various sort of structural reasons why that doesn't happen, which I can go into, which is quite difficult. But one of the reasons is that we have this paramountcy principle in relation to the Children Act, which means that the welfare of the child is the paramount consideration. And so the process is completely different to the process that's used by the European Court of Human Rights. So we don't start from a rights perspective, we start from a welfare perspective, and rights are fairly incidental and not expressly discussed in the Children Act at all. So I think that really hampers a proper discussion of rights in general, because you're not allowed, in effect, to discuss one's rights according to the legislation. I hope that made sense.
Yeah, no, that's really very interesting. Yeah. I've got several questions here. Do you want to say anything about that, or shall I pick up some of the questions and you can loop them together? But very happy for you to say something.
Can I see the questions? Are they in the chat? Sorry, are they in the questions?
I'll read them out so that a lot of people watch our recordings and then they don't get these.
Yeah. Great.
So,
okay.
I'm just wanting to ask Olive if there's anything she wanted to say just about that point, Olive.
I think, again, Shazia is right. Shazia is right. That's what I'm here to say. I think it's absolutely correct that family lawyers who think that I think it's a little bit of laziness, actually. I think family lawyers think that they are protecting people's rights, but they have this mentality that the welfare principle just means that everything in relation to the rights issues will kind of all work themselves out as long as they're applying the welfare principle. And that's the kind of laziness of thought and a lack of proper analysis of the human rights issues. But that's because they're not reading the human rights. They're not reading European Court of Human Rights decisions. Yeah.
Yeah, although the paramountcy principle is very difficult, and for example, under the Hague Convention in relation to the abduction of children, you say exactly the same issues arising between the paramountcy principle in relation to kind of return, and then where does domestic abuse fit into the picture? And it's quite difficult doctrinally to actually find a place for it to fit in. But turning to some of our questions, so we've got a question from somebody which has just asked about the way in which courts and the legal system often perceive women is as so-called emotional, and how is it possible to overcome this misogynistic view of women in the use of women's rights, and particularly as contrasted, as Shazia told us, in relation to men who may become emotional, who are perceived in entirely different terms. Shazia, any thoughts there? And then we'll turn to Olive.
Yeah, I think it's, and I think even when they're not emotional, we saw that. So there was one respondent who was who actually had a law degree and was really articulate and was really calm and rational. How she thought she had to come across, and then she actually was criticised for this as being too calm, too rational. So I don't think you can win either way. So even if you weren't emotional, so how do we deal with this? Well, again, I think it's making it's getting proper training for judges, where they actually understand what, how that. There's this constant problem, I think, about the ideal victim that we have in general relation to violence against women, but we definitely have an ideal victim of domestic abuse going on. I think for judges to confront that would be very, very useful in terms of training, and that would be a good start, which is, what do they think a victim ought to be? And how does that manifest in their courtrooms, and is that fair? So there's lots of things you can do, but I think it's got to be very, very good judicial training, and it can't. And the fact that we don't know how much judicial training is actually given on domestic abuse, and nobody will answer the question, is very concerning.
Yeah. Olive?
Yeah, it's a great question. Like I said, it's where we really started with the conversation in rights of women, was the issue of the cultural attitudes, which obviously we would think includes misogyny, that women face in the family court. And I think one of the real benefits is not going to suddenly solve everybody's problems, but I do think one of the benefits of human rights arguments and discourses is that they can be viewed as more rational and more legalistic. This is not about, oh, a victim of abuse who needs to be protected, and you may have whatever views you are going to have about domestic abuse and women, which many family court judges still have, that are pretty misogynistic. But when it's put into a legal framework, it gives it legitimization, that the judiciary are, that's what they're meant to be. They're rational, objective. These are legal arguments that they have to pay attention to. So I certainly don't think it's going to suddenly solve the problem of misogyny in the family courts, but I do think it would be a step in the right direction.
Yeah, thank you. So the next two questions, the first one is, why is there a divergent practice between child protection proceedings and private family law in respect to direct contact with a parent who is alleged to be a domestic violence perpetrator? So why do those two different proceedings diverge? And secondly, to what extent do judges and lawyers understand the positive obligations under Articles 2 and 3? And do you think that it's a failure to consider the positive obligations imposed upon states by Articles 2 and 3 that might lead to the way in which, I suppose, Article 8 and Article 2 and 3 are being read together? So do you think that there's sort of ignorance and skepticism about those positive obligations that perhaps might be shifting the balance between the rights in favour of Article 8?
Shall I go first? Okay, so in terms of why there's a divergence, I think child protection proceedings are focused very much on safeguarding and child protection. So they are probably more alive to safeguarding and risk assessment than perhaps in the private courts are. I mean, they should be equal, but it clearly isn't. So I think that is the focus of child protection, right? To safeguard, risk assess, focus on protection of the child. I think also there's the difference between the vertical and the horizontal effect of the Human Rights Act as well. So clearly, that's the state in terms of the child protection agencies. So the state, they're much more alive to their obligations because they are agents of the state in that respect. Whereas I think the courts in relation to the private family court, the private family arena, I think haven't understood, or for whatever reason, it's the sort of the horizontal versus vertical, right? So they have an actual duty there, and I just don't think that a lot of courts either understand it or are aware of it. And I actually do think it's ignorance, actually, most of the time. Having spoken to quite a few judges, I think it probably is ignorance. It might be as simple as that they do have responsibilities in relation to stepping into these cases between two private individuals. So I think there's a misunderstanding of the horizontal and vertical effect of the Human Rights Act. And in relation to number two, I think it's probably more ignorance, to be honest, rather than skepticism. There may be some, but I think it's largely ignorance. I don't know whether Oliver agrees with me.
Yeah, in relation to the second question, absolutely. I think that's the answer. They don't understand it. The first question is a really interesting one. I think there's some really complex things going on in terms of the differences between child protection proceedings and private family law proceedings. And some of those are really rooted in, again, one of the things I hinted at is the difference between mothering and fathering, perceptions of mothers and what's expected of them, and misogyny. So in child protection proceedings, you have a third-party professional telling the court, this is domestic abuse and it's serious and we need to protect the children from it. So you immediately have, it's not a woman saying, I'm a victim of domestic abuse and want you to protect me. It is a third-party professional, the state, stepping in and saying, this is what's happening in this case, and the court is going to be significantly more likely to believe them because of that. And they're also more likely to believe their assessment, the social worker's assessment of risk. So I think that's what's happening in child protection proceedings. In private family law proceedings, that's not happening. It's women who are asking the court to believe them and believe their view about the risk. But there's also, outside of them or beyond the misogyny inbuilt into it, there's also really interesting things, I think, going on in terms of the court's cultural perceptions of private family law proceedings. And there's an enormous amount of misunderstanding about the types of families that end up in private family law proceedings. And there is still, has been since I started in practice, there is still a view of parents who are in private family law proceedings that they're just difficult people who, you know, were going through a bad breakup and couldn't agree between themselves. So there's that very basic mentality still going on in private family law proceedings. The court can't get its head around the idea that there's enormous numbers of victims of abuse out there who are seeking the court's protection, and social workers aren't doing anything about it. So I think there's a few different things going on in terms of the differences in practice, but those are some of them.
Thank you. And in fact, the next question relates, I think, to the answers you've both given, and it might be quite briefly answered, which is, given how you both spoke on the key role of frontline lawyers and how they may not be steeped in women's international and regional human rights, does this mean that we need to get these arguments for courts, we need to equip law students and lawyers with better education on women's rights?
Yes, sure. Yeah, of course. Yeah. And I think more and more, I think the fragility really of women's human rights. So you can see that we made all these gains, I think, in terms of women's movement and the feminist movement, in terms of, you know, where we started from. I was talking about this with yesterday with Olive. It's a grassroots initiative that led to, you know, CEDAW, and it was the women's, actually, it was the International Women's Refuge movement actually that brought a lot of this into reality. So I think it seems like it's almost going backwards, and I work a lot with CSOs in this area, and it seems to be very much going backwards in that sense. And a lot of this is about funding and not having the funding, and just being exhausted, not having the time and energy and resources to work on the campaigning side of the women's movement, when you're having to constantly work to fund your organisation so it can carry on existing and, you know, provide services. You don't have the time for the relentless campaign. So that's why the role of the lawyer is really, really important, because to a certain extent, I think the women's movement as such has been decimated in that sense, that their ability to campaign has become more and more difficult. So lawyers are really, really important, and yes, we do need to, I think, really get across, you know, how important these issues are to both men and women students as well. So yeah.
Thanks, Shazia. Olive, anything you'd like to add to that?
Yeah, I mean, I said that family lawyers are not particularly radical, because they're not. The only ones really who do have a little bit of willingness to be more radical are those who work in legal aid, and the reality is that the sustainability of the legal aid profession is seriously under question. It really is on its knees. So just doing your day-to-day job is hard enough without having to go and look for what are going to be pretty radical arguments and the right case to pursue them in. The other thing is that we talk, and we do this as well at Rights of Women, we talk a lot about training the judiciary and all of that. We never really talk about training the legal profession itself. And they do need training. It's not enough to simply train the judges. The lawyers need that training as well.
Yeah, cases are conceived by lawyers actually at the end of the day very often and presented to courts. So then there are two questions. So one of them I'm going to put first from the same person, but it's really whether in fact, in focusing on kind of misogynistic attitudes in relation to the legal profession and judges, are we overlooking actually some baseline difficulties with the law? Is there something actually in the law outside of what may be the attitudes to applying it and seeking to rely on it that actually might be a problem? And then the same person asked a slightly different question, which is how we could expect to change the rules relating to the legal system in the context of parliamentary idea that Parliament determines these legislation, and in the context very often of quite widely shared superannuated stereotypes.
Wow, okay. I think it's mainly the problem with the misogynistic culture rather than the laws themselves. I mean, the laws, obviously, you know, there's always room for improvement, but we can see that there, you know, there's been lots of really good initiatives. I mean, there's been various practice directions. You know, they're not perfect, but they have tried. But the problem has been implementation. So it's always the case where we have great laws in lots of areas of the world, but it's actually the implementation that makes the difference. So I think what's preventing the implementation is sometimes attitudes and cultural, cultural issues, but also resources as well. So I think we mustn't forget the importance of resources. So they might well be, in order to achieve that change, that cultural change, we need to commit resources to proper training of lawyers and judges, as we've just talked about. So resources are really, really important. So yeah, that would be my answer there. And then what was the same question? How can we expect to make
the question about parliamentary sovereignty and stereotypes?
Well, I think that's linked to my answer before, isn't it? So I think, sovereignty has obviously been made. Sovereignty has taken place in relation to the law that we're applying, right? So that isn't so much the issue for me. The issue is more about the implementation. I don't think there seems to be an issue about who has sovereignty and political discourse, because I think there have been really good, because of all the research over the last 20, 30 years. In fact, we now have the Domestic Abuse Act, imperfect as it is, but the point is that has been achieved, and ultimately Parliament decides. But even the limited reforms that have been introduced by this Act and various policy changes have not taken place because we just haven't had the resources, and we haven't had the cultural, I think, will to change either. So that would be my answer.
Olive, anything in relation to those two?
The only thing I would add is that if you're talking about primary legislation, I don't think the main issue is with primary legislation, although, yeah, sure, there are ways in which it could be tweaked that might be better. If you're thinking about the law in terms of the procedure, yeah, I think there are changes that could be made to the ways in which the family court makes decisions that would be an improvement. And that was what the conclusion of the Harm Panel report was. And actually the government has agreed that they will pilot, we're kind of phrasing a different model of justice or a different way of reaching decisions. That is going to be, I think they're just starting the pilot, so it'll be a 2-year pilot before we know what the outcome of that is. By itself, that's not going to change anything. You still need the cultural change. You need the laws to be implemented in what I would call proper ways, but certainly different from the way they're being implemented at the moment. But in relation to legal change, if you include those processes, then yeah, there are quite important legal changes that we could make.
Thank you. So then the next question is whether human rights is in fact the right lens to try to address this problem, given that human rights would support a father's right to access. Would it be better instead to have thinking about a relational ethic of care, or something which is not so kind of based on a kind of liberal individualist equality between the parents notion, but something which actually recognizes the ethic of care as primary in thinking about how these disputes should be resolved?
This is a great question. I'm not a big fan of ethic of care as an approach. I fundamentally find it really difficult. It seems to me it's another way of saying, well, women just, and this is one of the issues that came up in the research, which is women are always arguing against the interests, arguing their own interests in addition to, so arguing other people's interests, usually children, and then there's a kind of added on. And I think that, and I don't like this sort of notion that it's just, that there's a sort of gendered way of looking at human rights. I find that really unpersuasive, and I think women are perfectly capable of looking at things from an ethics of justice and from a human rights perspective. So this sort of, I've always found this really difficult about the ethics of care versus ethics of justice. It's almost kind of, I think it's pretty patronizing, to be honest, as well. I just think women can use human rights. We've shown how we can use human rights. In fact, we've got concrete results from using human rights at the international level. So the next challenge is, how do we translate that? So we use that same energy, we use the same ethics of justice approach to translate it at the domestic level. So we don't abandon human rights. We don't abandon human rights to men, which is effectively what you would be doing. Yeah.
Olive, any thoughts on that?
No. I don't have anything to add. I agree with Shazia.
So then another question comes back to the point we were discussing earlier, which is really the point Olive made about how junior lawyers sort of get acculturated into an existing system quite quickly and therefore don't challenge its basic premises and practices, and whether there is any way in which we could take some initiatives within a university setting proactively to try to sort of immunize people to some extent against an easy adoption of a culture which is misogynistic or not focusing at all on women's human rights?
Let's try and answer this, because I think it's probably better from your perspective, because you're out there, aren't you? What could we do in universities?
Well, you definitely need to teach it in the first place. There are, significant numbers of young lawyers coming through who've never learned any of these things. They just don't know about it. So ensuring that it's a core part of the curriculum would really help. You know what, I'm stumped because I haven't had to think about this before, what universities could be doing. I think there's perhaps a role for academics as well in reaching out to lawyers who are already doing the work, and building connections with lawyers. Things like the way lawyers get their CPD is, a set of chambers will set up a seminar and a group of lawyers will go along and they'll do a legal update on these are the recent cases that have been published and teach us all about what we need to be applying to our cases in the future. Good connections between academics and lawyers who are willing to set up seminars like that, programs like that, actually aimed at lawyers who are currently in practice rather than waiting for today's students to become tomorrow's lawyers and judges, is something that actually I think would be really helpful, because we don't, lawyers don't, we're not reading academic papers, even the ones that we can access, we're not reading them. So there's perhaps some really helpful reaching out that could be done to say, we have all of this information, we want to share it with you.
Yeah.
Yeah.
That's a very interesting idea. And, one of the things that Bonavera does, we do actually run a kind of non-credit courses for existing students on key human rights issues. So it does strike me actually that this would be a suitable area for exploring how you think strategically about addressing these issues. Some of the things you were talking about earlier, Olive, about thinking about, could one get some constructive case law here, which might actually change the fundamental attitudes and thinking about how you think about these legal problems. So that's an interesting idea.
Can I just, just wanted to add about family law, because family law is an option generally, and so it's quite a popular option, I think, in most universities. And my kind of anecdotal experience over the last 15 years is that predominantly women take it. So it's really interesting that you think, would you, I don't know, can you make family law mandatory? I don't know. But given it's such a, that would be great, obviously. But I think encouraging more men to take family law would be a good start as well. But yes, teaching about domestic abuse. And, I can think of one major competitor who, does not even cover domestic violence on their family law course, which I find absolutely shocking. So, so I think there's definitely got to be, if you're offering a family law module, it has to cover domestic abuse.
Yeah,
I don't know how you could not, but that clearly does happen. So that's a really, really, I think, pretty basic thing that we should be doing as a university. But I absolutely agree with Olive about, academics engaging with practitioners wherever possible is really good. Yeah, sorry, Kate, I interrupted you.
No. All I was going to say is, we haven't mentioned criminal law, and we haven't discussed actually at all how inadequate the law is at keeping women safe. So that, in circumstances even where they have prevention orders or, protection orders in relation to domestic abuse, actually this is an area where the law is really very weak, and systems of law enforcement are very weak at protecting women, which is a sort of side of this which we haven't talked about at all. Did that come up at all in your research, Shazia, that potentially women's skepticism also arose out of the vulnerability and the failure of the law enforcement to protect them at all in these circumstances?
Well, surprisingly, actually, quite a lot of women had quite positive experiences with the criminal law, actually. They were saying, actually, they found, and again, because that kind of planet analysis, I think is quite important, because, again, the police are focused on, and there have been, to be fair to the police, there have been lots and lots of initiatives over the last 10, 20 years in relation to domestic abuse, which have been really, really positive. Unfortunately, we're now going backwards because, again, resources haven't been allocated. But they were doing quite well for a while, certainly in terms of protection orders and all that, DVPOs. We've got all these kind of new initiatives that are going on. I mean, obviously, there's a huge systemic problem with police officers, as we know. But in terms of initiatives and what they were trying to do, they were trying to do something. So what we found is that the women were saying, actually, the criminal response was actually largely positive. But there was no communication going on between the family courts and what was going on in the criminal courts. So as you saw in one of the examples that I gave from the focus group, you know, there were records of criminal convictions against this father, but they were just disregarded in the family court. It was really bizarre. So I think that's what was going on. So actually, we didn't really have too many women, I mean, obviously it wasn't a huge sample, saying that they had a bad experience with the criminal. Actually, it was the opposite. But there was this contradiction between what the police were saying, which is, you know, bail conditions, you can't come to this house, you can't, you know, you need to keep them away from you and the children. But then they go to the family courts and the family says, no, you have to facilitate contact. That was the problem.
So that's the 3-planet problem that you did at the beginning. Great. Well, the last question we've got, and I'm just saying to people, we do have a minute or two more. Someone has just come in. Oh, yes, I see it has. But is what the role of third parties, such as social workers, risk assessments in contact cases, could potentially be in private court. So you've talked about how the role of social worker assessments in relation to child protection, but just wondered whether this question wonders whether there could be more involvement of that kind of third-party assessment in private family courts.
Well, there is a third party, which is CAFCAS, which is supposed to write a report and make recommendations. I don't know if Olive will agree with me, but my experience years and years ago in practice was they very rarely gave any recommendations at all and usually sat on the fence. It was really, really difficult, and there wasn't really any real investigation. And there's been lots and lots of complaints about how CAFCAS court reporters actually do their work, and that it's often very, very poor quality, basically, and they don't really get into the real dynamics. And then, of course, they've got their own cultural problems about their own, you know, sort of stereotypes about what an ideal victim of domestic abuse would look like. And so there's been lots and lots of complaints about CAFCAS as well. So I'm not convinced that a third party necessarily is going to be better. I mean, there is the possibility anyway within the current legislation for the courts to order a social work assessment where they think child protection issues are relevant, but they very rarely do in these cases. So again, it's that sort of disjuncture where it's still child protection safeguarding, but it's not regarded as serious enough to bring, because of course there's resource implications again. Social workers are obviously completely massively overworked and under-resourced. So yes, I mean, I think in theory it sounds great, but in practice, you know, you've then got another party that's got all these kind of cultural problems that we know about. Yeah,
thank you. Olive, any thoughts on that?
Yeah, I do. For the first time, I'll slightly disagree with Shazia.
Okay, great.
So one of the ideas behind the pilot that the Ministry of Justice is looking at the moment, coming out of the Harm Panel report, is partly this idea of having more third-party involvement in cases from the start. Now, who those third parties are really matters. Certainly, I agree with Shazia, there's been a lot of problems with CAFCAS. But the basic idea that you don't leave a judge by themselves to make these decisions without any outside input, I think is absolutely right. So I feel reasonably positive at the moment about the opportunities that this pilot might present of having third parties involved. It's not only going to be CAFCAS, but also part of the idea is that CAFCAS will be more willing and more resources will be put into them reaching out to even things like finding out better information from the school about, you know, how the children are getting on, medical professionals, the police, and fingers crossed domestic abuse support services who are really able to actually do proper risk assessments. And with a group of professionals being able to provide an opinion, I think you're more likely to improve decision making by judges. So who those professionals are and what the training available for those professionals is and the resources available all matters. But as a basic idea, yeah, I think it has positive or opportunities.
Great. Yeah, to clarify, yeah, no, I absolutely agree there should be a third party. I guess I was saying we should improve the ones we have. which is Kafka's. And yes, exactly. Yeah, there definitely should be a third party, but well resourced and doing it properly. That's been the problem, hasn't it?
Yeah, and that's back to the resource constraints that you mentioned a few times.
Yeah.
So the last question is just about, back to the universities and the point that you made, Shazia, about family law not mandatory course, and that nor is human rights in Oxford at least. And so whether in fact they end up kind of competing with one another, both in terms of timetabling or limited numbers, or whether they're seen as too similar or softer modules, etc. I mean, any thoughts on that?
That's a question. I don't know how it's timetabled here. I've got no idea. But yes, I mean, I think optional subjects that are quite popular often are, again, so you're in not that you're in competition, but I think there's again, I don't know about Oxford, but there is this tendency among students, I think, to think that they can only kind of take one sort of socially justicey module, and then they've got to do everything else to get a job, and especially if they want to join a city firm or whatever. So it's a fairly self-selecting group that takes family law anyway, I think, because of that reason. I don't know if it's, I mean, I teach, obviously my research is in human rights, so I've always taught human rights, family law from a human rights perspective, and I would hope that others do the same. So it depends very much how you frame it. Yeah, I don't know. I mean, I don't think it's a softer module, but I think I don't know. It'd be really interesting to hear from the students about how they perceive it, because I don't know. Obviously, I've been teaching it for years, but I think in a way the answer lies with the students who perhaps are here today. Whether we could take a little vote. I don't know. What do they think we should do?
I'm not technically competent.
No, don't worry. I don't know how to do that either.
People, they can always put their comment in the Q&A.
Yeah, it'd be good to know. Yeah. If Naomi's got any thoughts herself.
Yeah. So I know that Naomi's an early career fellow here in Oxford, but we need to know what people think. So I think that really brings us to the end. Thanks very much indeed, Shazia and Olive, for a fascinating conversation on a really important topic and really interesting research, Shazia, and also very good to get to know the work of Rights of Women, Olive. And then just thank all of those who have attended, and just to remind you that there are several other events coming up at the Bonavero. Firstly, there are 2 book launches this week, both actually taking place tomorrow. One is on the marketization of socioeconomic rights and state obligations, and that's at 12:30 tomorrow. And then the next one tomorrow at 3:30 is a theory of African constitutionalism, both online, so please do register for those if you're interested. And then the discussion group next Tuesday will be on comparing the Islamic and international laws of war, orthodoxy, heresy, and secularization in relation to the categories of civilians, presented by Lena Salome with Patricia Vizeur-Sellers as the discussant. So please register for those. As you know, discussion group this term is online. So finally, again, just to thank you, Shazia and Olive. It's always a pity at the end not to be able to have a chat and a cup of tea about the really interesting presentations. I hope that opportunity will arise before too long. And meanwhile, well, and thanks a lot.
Thank you. Thanks, everybody.
Thank you.
Okay, bye now.
Bye. Bye-bye.